Hello. Thank you so much for joining us for the panel today on colonialism as genocide in slow motion. As you know, this year's conference is about diversity in international law, and our panel is here to talk about what happens, the consequences and ramifications of a lack of diversity in the creation and practice of international law. Not just a lack of diverse voices at the table, but the exclusion of people who were directly affected by the decisions being made at that table. We'll be focusing on the Genocide Convention in particular. However, the lessons to be learned are applicable to many other treaties, conventions, and international agreements, including those that are being actively drafted today. The objective of the panel is not only to highlight the shortcomings of the Genocide Convention due to a lack of diversity, but how we can use international legal tools to fight for justice for communities who otherwise were not intended to benefit from them. For those of you based in Canada, you will be aware of the National Inquiry into Missing and Murdered Indigenous Women and Girls. After spending 2 years hearing testimony and information from thousands of victims, survivors, and family members, the inquiry concluded that the root cause of the disproportionate violence against Indigenous women, girls, and Two-Spirited people was an ongoing genocide against Indigenous peoples in Canada. We're very lucky to have an all-women panel here today to discuss the National Inquiry's findings and to explore whether the Genocide Convention and international criminal law more broadly can and should be used or not in the struggle by Indigenous communities to end centuries of oppression, discrimination, and attempted annihilation. You should all have access to our longer biographies, and I encourage you to read them, so I'm only going to give a brief introduction of our panelists today. We were supposed to have Michelle Odette with us, who is a recognized Indigenous leader for her many years of service in politics and community and one of the commissioners of the National Inquiry. Unfortunately, she's unable to join us today, but we have the rest of the panel, and we hope that we can fill up that time with some interesting discussions. We have Pam Palmater here, who is a Mi'kmaq citizen and member of the Eel River Bar First Nation in northern New Brunswick. She's a lawyer, an associate professor, and the chair in Indigenous governance at Ryerson University. Her scholarship was heavily cited in the National Inquiry's supplementary report on genocide, and we're very happy that you're able to join us. We also have the three-member team who drafted the National Inquiry's legal analysis on genocide. Fanny Lafontaine is a professor and prolific scholar at Université Laval. She has too many research and chair titles for me to name here, but she's also the director of the Canadian Partnership for International Justice, and she led our team in the drafting of the supplementary report. We have Catherine Savard, who is one of Fanny's LLM students and heavily contributed to this report. And my name is Amanda Garamani, and I'm an international human rights lawyer who also helped co-draft the legal analysis, and I'm the chair and the discussant of the panel today. Before I begin, just a quick note on the structure of today's session. All of us will be participating in a conversation and in a discussion, after which, if we have time, we'll be opening it up to the audience to ask some questions. The panel is going to be recorded today, but the Q&A won't be, so I highly encourage you to step up to the mic and ask some questions later today. We also have copies of the National Inquiry's report that are outside in both English and French, so if any of you haven't actually read it, we highly encourage you to pick up a copy and read it on your train or plane rides home. Now, I would like to begin our discussion today by acknowledging that the land on which we gather is the traditional and unceded territory of the Algonquin Nation. Many of us here today make these land acknowledgements fairly regularly as a symbolic token of respect without really doing much more. So I'd like to take a moment today to provide a brief and admittedly simplified anecdote about the Algonquin land that we stand on, as it is incredibly relevant to our discussions today. The Government of Canada never made any land treaties directly with the Algonquin Nation. The Algonquin Nation never ceded their territory, but they were heavily impacted by land sales in the 1700s and 1800s between the Government of Canada and the Mississauga tribe. You see, the government increasingly bought portions of the Algonquin lands from the Mississauga tribe without ever discussing with or consulting the Algonquin people. In one instance, when the Algonquin chiefs became aware, they engaged in colonial judicial processes to petition the government to cancel the sale of their land. In this petition, the Algonquin chiefs explained that the deal was concluded, quote, without our knowledge, consent, or participation in any shape or manner. And this quote is emblematic of the troubling exclusion of Indigenous voices in both domestic law and in international law. Now, you might say, but actually, isn't it the Mississauga tribe who sold that land? Weren't there Indigenous voices there, and weren't they involved? And this is the problem with seeing diversity as tokenism, that merely having a woman, a person of color, a religious minority, or an Indigenous person, regardless of their privilege, is sufficient to be inclusive. Being inclusive, including in international law, is recognizing the power imbalances within diversity, the need for intersectionality, the need to not just check a box, but to meaningfully engage with those who will be most affected and impacted by the work. And this is precisely what did not happen when the Genocide Convention was being drafted and negotiated. After World War II and the conclusion of the ad hoc tribunals at Nuremberg and Tokyo, the crime of genocide became an important issue at the very first session of the UN General Assembly in 1946. Early notions of genocide reflected the work of Raphael Lemkin, the Polish jurist who coined the term, and who classified three types of genocide: physical genocide, which consisted of the physical destruction of a group; biological genocide, which was the destruction of the group's reproductive capacity; and cultural genocide, which yielded the destruction of structures and practices that allowed the group to keep living as a group. This was the starting point. At that UN General Assembly in 1946, they began the process, delegated to the Economic and Social Council, of drafting what will later become the Convention on the Prevention and Punishment of Genocide. This drafting process took place in several phases, culminating in negotiations at the General Assembly's Sixth Commission between, quote, civilized nations, which is already problematic language, as Payam noted yesterday. Indigenous voices were completely excluded from this process at all stages, not by ignorance or coincidence. This wasn't just oversight. In addition to plain racism, prominent members of the UN who were themselves colonial nations had a very clear motive to exclude Indigenous voices. Colonial states, including Canada, actively pushed for colonial genocide to be excluded from the convention, knowing that they were perpetrating this very type of conduct at the very same time that they were negotiating this treaty. This is, after all, precisely during the time of the residential schools here in Canada. As a result, the notion of cultural genocide was eventually withdrawn from the negotiations and did not appear in the final draft of the convention. And this has had a ripple effect. When statutes of the ad hoc international criminal tribunals were drafted based on customary international law, they looked to the Genocide Convention for their definition. When the Rome Statute was drafted, it too relied heavily on the definition in the Genocide Convention, and it also excluded cultural genocide from its scope. So where does that leave us? That's exactly what we're going to be discussing today on this panel, and we don't need to go far to answer that question. We can look right here in Canada to see the impact of those choices. We see the impact during the Truth and Reconciliation Commission, which concluded that the residential school system was cultural genocide, and yet survivors were left with no international legal recourse to address it. We also see the impact upon the release of the final report of the National Inquiry on Missing and Murdered Indigenous Women and Girls, where, despite demonstrating, in very tentative terms I might add, that Canada's treatment of Indigenous people can fulfill the legal requirements of the definition of genocide, as problematic as that definition is as it stands, there's backlash, even from within the legal community, claiming that the inquiry is trying to fit a square into a circle. So with that said, I'd like to start with Pam here. Pam, you had standing before the Commission and made submissions on genocide. Could you give us a brief overview of how the National Inquiry came to the conclusion that a genocide against Indigenous peoples was a root cause of this violence?
Thank you. It's actually a huge honor to be here with all of you who have worked on this, and I'm so sorry that Michelle couldn't come because she was very important in this, as were all the commissioners, and I think it is important that we're sitting here on unceded territory, which very much looks like ceded territory because the Indigenous peoples don't have the use, benefit, and control of that territory, which is in part how we came to this mess that we're in. What I really appreciate about the National Inquiry's finding on genocide is that this was not an academic exercise. This was not a bunch of people sitting around pontificating. This wasn't ivory tower stuff. This wasn't a political debate. The National Inquiry's finding on genocide was based on fact and law. And I don't know how many times I had to repeat that in the media, that this is not open for debate. That is in fact the finding based on fact and law. And that fact included all of the thousands of witnesses, you know, all of the family members and survivors and people who testified to what has happened and what continues to happen. So there's a very important dimension there. It's not like we're talking about the Truth and Reconciliation Commission, which we're saying, look at this thing that happened in history. You know, let's recognize it and commemorate it and apologize and move forward. This is ongoing. And I think that was probably the most upsetting finding for people, is that this isn't just historic genocide, it's ongoing. And the fact that they also relied on experts, you know, not just the people with standing, but people who are recognized with expertise in this area and all of the things that made up genocide. And then they went and did their own independent legal research, because I'm sure there was some degree of foresight that even mentioning the word, there was going to be people in society saying, if it's not the Holocaust, it's not genocide. And people don't understand that the Holocaust is not the standard for genocide. It's one of the worst that's ever, worst examples of genocide. But it's not a competition. And you can't compare what happens in one country at a specific time period with specific politics and laws and people with what happens in another. They're all very unique and they unravel differently. And I think their supplementary submission on genocide really lays that out. And you could probably take that and apply it to Australia and New Zealand and the United States and the Pacific Islands and all of the other places where genocide has rolled out over time, more or less at different times. The other thing I really appreciated about their finding is that they were very direct, that this wasn't a bunch of benign policies. Like, well, we really wanted to give them education, we really wanted to civilize them, and oops, some bad things happened. That this was a manifest pattern, a clear intention of wanting to destroy Indigenous peoples in a variety of ways. That could be lethally, that could be culturally, that could be physically, it could be biologically, but they were able to shed the adjectives which act as limitations on genocide. It's like, we're calling it genocide. These are all the different ways in which it can happen, but it's genocide, and there's no limiting adjective to it, because the debate pre-National Inquiry had all been around, is it cultural genocide, is it real genocide, and there's just, those distinctions are not appropriate in this case. And the fact that they called it as race-based and sex-based genocide was very, very important, because those two things combine to make it very targeted and very focused on Indigenous women and girls. And we hadn't had a light that shone specifically on the gendered impact on Indigenous women and girls in this way before. We've had lots of justice inquiries that talked about racism, but not in a very focused way about how was it targeted against Indigenous women and girls. So I think those were some really significant contributions around that. And it's also, I think, an educational piece, because most people don't know what are the 5 criteria of genocide under the UN Convention. What was customary international law before the convention? What are all the different ways? And most people thought it was just mass killing in a short period of time. And while that's part of it, it's also all of the other things that go along with it. You know, the physical harm, mental harm, stealing of kids, prevention of births, and particularly right now, creating the conditions of life that will destroy people in whole or in part. So that alone, I think, was significant, and we just need to carry that forward.
Now, when the report came out and the term genocide was used, there was a lot of backlash. There seems to be a lack of understanding about the specific policies and conduct against Indigenous people that actually qualify as genocidal according to the definition that stands. Could you give us some concrete examples of genocidal conduct being perpetrated today?
Yeah, so, I mean, that's probably the most uncomfortable part for Canadians. It's the most uncomfortable part for students and trying to deal with it in the media, is that it's ongoing. It's just that we might use different terminology for it. However, there are certain examples like forced and coerced sterilization of Indigenous women and girls is something that happened in history, but it's ongoing, and we're in the middle of a class action lawsuit in different provinces for ongoing forced and coerced sterilization. And when I say sterilization, that also includes forced and coerced abortions, forced and coerced use of birth control, anything around preventing the ability of an Indigenous woman or a girl to procreate. And so that's significant. The other thing is that people get hung up on terminology. So a historical example would be residential schools, where children were stolen from families and forced to be in residential schools where they were physically and sexually abused, tortured, starved, neglected, medically experimented on. And so they think, well, the last one closed in 1996, so that's historical. However, we're doing the identical same thing today under the foster care system. And I think that's what's shocking to people. They misunderstand that the foster care system is rescuing children from situations of neglect, when in fact, the statistics show that the children that are stolen from Indigenous women and families, it's far more likely because of conditions of poverty versus physical or sexual abuse. In fact, it's Canadian children that are more likely to be physically and sexually abused than Indigenous children. So, but the problem is that they're still being sexually abused, physically abused. They're the #1 targets of human traffickers. They're far more likely to end up in corrections and then prison when they're adults than get an education. Less than 50% end up getting an education. And they end up as murdered and missing Indigenous girls. So you have all, these are just a few examples, but if you think about historically the way in which the Northwest Mounted Police used to sexually exploit Indigenous women and girls by using rations held by Indian agents, so the community wouldn't get rations unless girls were offered up for these police. And nowadays you have rampant sexual abuse within policing and corrections with almost 100% impunity. There's no way for us to get at that. Police unions block access to information. The only way we're able to shed any light on it is when international human rights groups come in and document what's happening. Deaths in police custody. If you think about, starlight tours, these are not benign acts of excessive use of force. This is when police officers go and take people, drive them out of town for no legal reason, and then they freeze to death. But for women, there's the added sexualized violence dimension, like in Quebec, where you pick up the Indigenous women, drive them out of town, sexually abuse them, and then leave them there. So all of these things that have happened in the past are still happening today. Think about starvation policies, clearing the plains, to force treaties to be signed in languages that Indigenous people didn't know. Today, what do we have? We have chronically, purposefully, and racially discriminatory underfunded funding for kids in care, for housing, for education, for basics of water. Food insecurity is rampant in First Nations. So these are all creating the conditions of life that have resulted in the premature deaths of Indigenous people, especially Indigenous women and girls. We have higher suicide attempts, we have the highest rates of heart attack and stroke, and that just doubles if you take their children and put them in foster care, for example. So, there's literally 1,000 examples, but that's the uncomfortable part, because we wish we could look at it and say this is a terrible legacy of the past, and what we're dealing with is just intergenerational trauma, but it's not. It's ongoing, and that's the really difficult part about their finding.
Thanks, Pam. Does anybody else want to add or bring more to that?
Well, go ahead. We'll, I guess, yeah.
Okay. So you bring up a really interesting point, because Indigenous voices were not the only ones that were excluded in the negotiation and creation of the Genocide Convention. Women's perspectives and lived experiences are also missing. And as your examples show, there is a gendered quality to genocide, and it's not often reflected in mainstream analyses of the crime, though there's been a lot of progress, as Valerie spoke about earlier this morning. Catherine, my question is for you. How does the exclusion of women's perspectives affect the way genocide was formulated and defined in the Genocide Convention and in subsequent jurisprudence?
Bonjour. Thank you very much. First, I'd like to say how a pleasure and an honor it is for me to be speaking here along with these fantastic women. And thanks to the CCIL, and thanks for you all to be here, as I think it's a very important conversation to have, and hopefully, well, it must continue within Canadian society today. So, yes, as you mentioned, the definition enshrined in the Genocide Convention, which is, by the way, the definition universally recognized of genocide in international criminal law. It's also part of customary international law. So this definition can be criticized for its failure to acknowledge the highly gendered component of genocide. So first, I'd like to address why is genocide a highly gendered concept, and second, how it was subsequently recognized in jurisprudence. So, at the outset, we must say, as Pam brilliantly pointed out, that genocide consists in both lethal and non-lethal acts. So killing is but one way of perpetrating genocide. So only forcible transfer of children, for example, is enough. So is infliction of mental harm, for example. Also, it was recognized between ad hoc tribunals that acts of slow death also fall within the definition of genocide. And these acts of slow death are acts who do not immediately lead to the death of members of the group. So this includes lacks of water, lacks of food, lacks of access to food, lacks of access to medical care as well. And all of these non-lethal acts disproportionately affect women because of all of the social vulnerabilities they foster. So that's it. Then when we analyze the menswear from a perpetrator's perspective, when we analyze how the intent is framed, we see that as a gendered component is often woven into the perpetrator's menswear, because the perpetration of gender-destructive acts maximize the destructive impact of the acts perpetrated. So, in other words, targeting victims in a gender-oriented manner destroy not only the group physically, but also it destroys the very foundations of the group. It destroys its social unity as well. And that being said, it leaves long-lasting scars within the group's social fabric, and it's inherent to its destruction. So that's how genocide is perpetrated. But now, how does that align with positive law, and how was it recognized in jurisprudence? So the very first judgment based on the interpretation of Article 2, the definition of the Genocide Convention, provided in the Genocide Convention, this first case law was in 1998 before the International Criminal Tribunal for the Rwanda. It was the trial of Jean-Paul Akayesu. And this judgment is very interesting as we know, rape, it affirmed that rape constitutes genocide. So that's very interesting because it draws attention to what kind of destruction is that. The ICTR emphasized the link between sexual and gender-based violence and infliction of physical and mental harm. It affirmed that actually rape and sexual violence constitute one of the worst ways of inflicting bodily and mental harm because it's both, at the time, both bodily and mental harm. But interestingly, the ICTR affirmed that sexual violence was an integral part of the process of destruction, disproportionately targeting women, contributing to the destruction of the Tutsi group as a whole. So it contributed to the destruction of the spirit of the group, of the will to live, and of life itself within the group. So we see that's only an example of how the perpetration of a gender-oriented act disproportionately affects the group as a whole. And I really need to mention that I'm speaking of rape and sexual and gender-based violence, but women's experience in genocide is way wider than that. Actually, all of the elements of the actus reus of genocide can be perpetrated in a very gendered manner. We see it, for example, during the Rohingya genocide. We see that only the way that some people are killed depends on their gender. For example, men tend to be shot or killed more quickly, while some women are stabbed and burned, which is a typical way of destroying means of property. So it evinces a gender conception of power, dominance, and masculinity. So even arguably gender-neutral acts of genocide can be perpetrated in a very gendered manner, so in order to maximize the destruction of the group. So coming back to Canada now and work of the inquiry, this gendered approach to genocide that we followed in the legal analysis allows to explain why a commission of inquiry which focused on women and girls can make a finding of genocide like perpetrated against Indigenous people as a whole, and not only women and girls, because it witnessed first-handedly the scars in the social fabric and the social vulnerabilities that stems from this genocide. So that's what I want to say for now. If you.
Thanks. Fanny, do you have anything to add? Or Pam, do you want to add anything to that answer? Or
I suspect what your next question will be, so maybe I'll cover this. But it's interesting because the way the genocidal acts in the convention, in the definition of the convention, which became the definition that was replicated in other statutes, etc., was interpreted by tribunals and interpreted to include, as Valerie has documented over the years, as Catherine has just said, acts of sexual violence, acts of other nature that weren't you don't see that when you read the definition, but it became clear that mental harm, physical harm, and conditions imposed, calculated to whatever, the third paragraph of the definition, became clear that sexual violence, for instance, or other acts that are not specifically mentioned in the convention could be interpreted within those articles. And this probably leads up to one of the main probably contribution of the in National Inquiry's analysis is an interpretation of the convention that is within the context of the definition, with the object and purpose of the definition, but the gendered perspective on genocide, the gendered comprehension of the crime has evolved over the years, and nobody here could probably argue that in 1948, when the Genocide Convention was adopted, anybody could have foreseen that the type of sexual violence documented, for instance, in the Tutsi genocide would have been genocidal acts. But it does. So I'll come to that when I talk about the definition, but it's not a static definition. And to understand the definition with a gendered lens, as Catherine has said, allows us to understand the true nature of genocide within the definition, within how is it framed, but in its real meaning.
So just quickly, I mean, I think that's so important about the gendered aspect of it, because it is violence, it is harm, it's physical, it's mental harm, and it also harms the group, the individuals and the groups and families. And I think we also have to remember who the perpetrators are, because one of the things that the National Inquiry did was dispel with that myth that, oh, it's all Native men, so that's just between them and that can't be genocide, when in fact many news outlets and researchers and even the RCMP's own statistics don't bear that out, that the majority weren't even known, or they were just acquaintances. And an acquaintance can be a doctor, a lawyer, a social worker, a teacher, a foster parent. And so we're talking about a really complex way in which state-based genocide, so from state government officials, state agencies, state agents actively engage in genocide themselves as perpetrators, or set up the conditions of which genocide can take place and don't act to stop it, and how that intertwines with the genocide that is allowed by the state to take place by actors in society. So the ways in which, for example, a police officer can be involved in direct sexualized violence of Indigenous women and girls, thus denying her any access to justice to protect herself against other forms of genocide, or to be a passive player in allowing allowing human traffickers to take children from foster homes and hotels and group homes and engage in acts of human trafficking knowingly, but just allowing it to continue. So there's this really complex mix of state-based actors as allowing it in terms of complicity, but as actual perpetrators themselves, and then how they interact with society, and then what message that sends society. So, I mean, if Canada doesn't do anything about genocide, well, that's a pretty clear sign for human traffickers or anyone else, predators, to know that it's open season with a very high degree of impunity. And that's how genocide is really allowed to continue, both in state and society.
Well, you bring up a really good point about this distinction between state responsibility and then individual criminal responsibility. And the law also has these distinctions in terms of what is possible, what's feasible. And so, you know, much of international criminal law to date has developed as a reaction to popular notions of genocide as this kind of Holocaust model, as this type of massacre. And we have clear individual perpetrators in those types of situations. So the principles of international criminal law relate primarily to individual criminal responsibility. So I'd like to ask Fanny now, how can these principles translate and apply to state responsibility the way we see in the inquiry's report?
Yeah, I think it's something that was really misunderstood in most of the reactions to the National Inquiry's report. It's one of the things that was misunderstood, but that is one of the things that is misunderstood. The Genocide Convention is an interesting treaty because, I mean, it's well known that it creates individual criminal liability, but also state responsibility. This was confirmed. It's clear from the text in my view, but it was also confirmed by the International Court of Justice in the Bosnia case. But one thing that is also misunderstood, and Bill Shabus, who's an expert on genocide, along with our superstar Paya McAvan, who's in the room too, but also often tried to remind us of this very fact that we sometimes forget. The Genocide Convention is not primarily an international criminal law treaty. It's a human rights treaty. If you go to the UN treaty website, you know where they are, it's the first human rights treaty. And if you look at that convention in that lens, under that light, it brings a very different perspective on the obligations imposed on the state and the consequent sort of protections of the individuals. And that is very interesting because we don't often see it this way, because as you said, most of the developments post, you know, that occurred after the drafting of the convention were related to individual criminal liability. International Criminal Tribunal for Rwanda, International Criminal Tribunal for the former Yugoslavia with the Srebrenica trial. And so the way to understand genocide and to attract liability for the violation of the convention was very thought through on a criminal law perspective. So we try to bring it up and think about state responsibility for a violation of a human rights treaty, for an obligation of the state under international law. There's very few precedent. There's one case, I mentioned it, the International Court of Justice in the Bosnia case talked about the responsibility of the former Yugoslavia of Serbia for genocide, but it was really different because it was attributability of acts of non-state actors, armed group, to the state. And so it's very different from the colonial sort of genocide that we experience here, because the commission of the violation, the commission of the genocide here is directly attributable to organs of the state. So the precedent that we have in jurisprudence, and there's a few examples here and there, but there are very few precedents onto how to comprehend state liability for a violation of the convention. And so this is a first start, and I hope it triggers a lot of interest in Canadian academia and elsewhere to better understand what it means to be in violation of the Genocide Convention as a state. What the commission, what the National Inquiry came up is first to say, well, yeah, Canada is responsible through its different organs, through different decades, in different manners. It's not just one ministry or it's not just the police, it's different state organs which have at different moment committed different acts, which in aggregate constitute the violation of a convention. And this, for international law nerds, which I suspect a few in the room, is interesting because it mixes the principles of state liability, draft articles on state responsibility, with the normal comprehension we have of liability under the Genocide Convention. So the National Inquiry said basically, and this could be discussed, but identified or tried to qualify Canada's policies throughout the decades as a composite act, international law, which is basically a manner of violating an international obligation for a state. So it's a breach of an international obligation through a series of actions or omissions defined in aggregate as wrongful. So think about it. It's very hard because when we think of genocide, we think of massacres, and then we try to identify a very clear chain of liability, which is already very difficult for individuals. But as a state, to comprehend the violation, the different acts that Pam mentioned, that go in aggregate, in total, constitute the violation of the obligation contained in the Genocide Convention. So it's a different way of understanding this, and then we have a lot of work still to do on understanding as of when and how can you take the very old examples, not as evidence of genocidal acts or as violations of the Convention, but as evidence of how the more contemporary actions, post-1951, for instance, after Genocide Convention was enforced, constitute the violation. So it's interesting, and I want I really invite you to think about this, the violation as a state. And I'll just finish by saying this, and we'll talk about the definition. But if you look at it in this way, and you think as the state as the violator of the Genocide Convention, then you move away from a lot of the reflexes we have when we think of genocide. Who's responsible? If you look at the media, they all said, so what, we prosecute Justin Trudeau now? No, we don't. It's not about that. It doesn't mean that in certain cases, individuals did not also commit genocidal acts or have their irrelevant mens rea. It's not about that. Maybe. But it doesn't need that proof to establish that the state, through policies and through patterns of conduct and policy throughout the years, committed as a state a violation of international law. And this is a very unprecedented and very little looked at way of understanding the obligations stemming from the Genocide Convention.
Yeah. Does anyone want to add to that? Okay. Well, I'll pick up on that because you bring up this idea that, who's responsible? These reactions we're getting in media, in popular culture about how to really try to understand what the National Inquiry's conclusion really ended up being. And it seems that one of the impediments to a nuanced understanding of the crime of genocide, that is the legal elements of the crime, is the saturated presence in popular culture of genocide as the Holocaust, which we've brought up, or as this very egregious, time-intensive massacre, such as what we saw in Rwanda. But genocide is much broader than that. And Payam brought up yesterday that, you can look at it from a socio-legal perspective. You could look at it from, a broader perspective that is not just, law or international criminal law. And so, Catherine, I'd like to ask you, what is the role of international criminal law in prosecuting and punishing forms of genocide that fall outside of this traditional Holocaust model? Is it only up to kind of the sociologists to deal with it, or is there a place in international criminal law to actually deal with this type of genocide?
Thank you. Well, there's definitely a place in international criminal law for prosecuting these forms of genocide who fall outside the so-called Holocaust model. So let's dig a bit deeper on what's that Holocaust model first. So, because it perfuses a lot through popular conception and eventually also to the legal analysis of the crime as well. But arguably, maybe we should distinguish from that model, as I will explain. So the so-called Holocaust model is a very time-intensive atrocity. Consists mostly of mass murder planned by authoritarian leaders espousing ideological worldviews. So many of the genocide who have been subject to international jurisprudence more or less comply with that model. So we can think of the Rwanda, we can think of Yugoslavia, for example. But colonial genocide is different, but nevertheless falls within the international criminal law definition of genocide. And just a quick note, when we talk of colonial genocide, it means genocide, but perpetrated in colonial context. It's not like a cultural genocide, so arguably maybe it's not a real genocide. When we say colonial genocide, it means genocide. It's only a contextual precision. Okay. So about the conception that genocide is only mass murder, I think we've already talked a lot about it, that it includes also non-lethal acts, that like it's not it's killing is but one way of perpetrating genocide. In the Canadian context, yes, there were some physical destruction as well, but colonial structures and policies were also oriented towards the destruction of the group through violent and coercive absorption of this group within the colonial dominant power and culture. But all these non-lethal tactics and practices were no less genocidal, as they no less intended the destruction of the group only in a non-lethal way. Then, concerning the time-intensive component, that genocide should be limited within a certain period of time. Again, colonial genocide differs a lot. To the opposite, it must be construed as a slow-moving process involving state responsibility, as we already mentioned. So, as Fanny insisted, and I'll point it out again, it consists on distinct acts and a mission perpetrated by the states, and in aggregate, all of these acts, which fluctuate over time, and they change. They're not. It's not one uniform policy. But all of these acts, as a whole, consist the violation of international law. So it's again very different from every time limited, but no less constitute genocide, as I'll explain later. Concerning finally the ideological drive and the idea that genocide can only be committed in totalitarian or authoritarian regimes, and that they be the product of an individual mastermind with a deranged ideology or something. What I can say about that is, yes, racism was, it plays a role in colonialism. It was an underlying ideology, underlying this genocide, but nevertheless, it's really important to distinguish from our individual criminal liability perspective that's really anchored in our minds, and really view it from a state responsibility perspective, as we point. But now, I've highlighted that colonial genocide differs from our conceptions, but is that genocide at all? So we have to set aside our popular conception and really look with methodologically correct approach and look at the definition in the light of our principle of interpretation as laid down in the Vienna Convention on the Law of Treaties, mostly. So when we look at the text, there is no mention of time, there is no mention of any ideological requirement. The object and purpose of this treaty is to safeguard the very existence of human groups. It's about that. So there is no way that colonial genocide should fall outside of that as well. And the distanciation from the Holocaust model is further reinforced when we look at the travaux préparatoires as well, as one state representative actually suggested that a reference to the Holocaust should be included in the convention, and that was rejected, as state representatives voted and affirmed that including this express reference to the Holocaust in the Convention would set a threshold so high that then it would be almost impossible to make a finding of genocide afterwards. And arguably they were right. So, of course, we don't, the aim is not to negate the horrendous character of the Holocaust at all. It's not the point at all. But we just have to be really careful with this atrocity, which is really printed in the popular conception, and because it's not consistent with international criminal law, and it's actually dangerous because it directly leads to genocide denial, and which can be very worrying for the future of humankind, actually.
And I think that's a really important point, that Pam also brought up earlier today, which is that this isn't a competition. Just because genocide, according to the definition that we have, has happened in one place, it doesn't mean that it cannot occur somewhere else. And it doesn't mean that by virtue of naming it what it is, that we're negating anyone's suffering. The only thing that we would be negating by not doing that is the people who are deprived of the ability to name the conflict or what they've encountered or the harms that they've suffered as what they are, according to the definitions that we have today. And this brings us back to definition. This brings us back to this very flawed definition of genocide in the Genocide Convention because of a lack of Indigenous voices, because of a lack of women at the table. And so my question for Fanny now is whether it's, is it still useful and helpful for us to use the principles of international criminal law to qualify ongoing colonial policies against Indigenous communities as a slow, insidious form of genocide? Is it useful to use those principles, or should we reject the narrow legal definition of genocide in international law, or should we try to expand the terms that we have or the definitions that we have so that they better reflect the plural forms of genocide that have and continue to take place across the world? Or should we just refrain from using this terminology at all and develop a new term, as Payam suggested, perhaps even a new term, a new word rooted in one or many of the Indigenous languages in Canada? Where do we go from here? What can we do? It's a lot in 5 minutes.
Well, I don't think the question goes to me because it's not me or any of us actually who said it was a genocide, who thought it was a genocide. For Indigenous peoples, and Pam, please, tell us more about this, and I'll turn to you after just on this very point, because the chief commissioner of the National Inquiry said genocide was an inescapable conclusion from the evidence that they heard over the years that they were hearing this. And so this is not about whether it's the correct word. Now, whether it's the correct application within the legal definition, I'll answer your question. But whether it's the correct word or should they invent another word, that's not for us to say. That's the word they use because that's the word they saw as applying to the destruction that they felt over the years. And so if you read the way that the genocide issue is treated in the report, how the commissioners heard the evidence and said the root causes of what we're seeing for murdered and disappeared Indigenous women, the systemic causes. This is our mandate. What creates this is, and then this evidence that they gathered, touching everything of colonial policies of the past and of the present, came to them as is it inescapable, she said, or there was another greater word even, conclusion. This is genocide. Now, we look at the definition, and I'll come to this. I want you maybe to react to this, Pam, because you've been saying this for years, though. So using another terms, who are we to say that? So what genocide was for just a few people. So who gets to choose to use the word? If it fits with actions that aim at destruction of a group of people, it is genocide. Now you can look at the definition, and we can argue as jurists whether that aspect or that aspect, and we'll get to that. But the use of the word, if it's felt by the people, and then I repeat, it has to fit the definition for liability, for legal consequences. That's one thing. But is it a good word? Is it a good word, Pam? Is it?
I think it is a good word because it's what it is. And I think our problem and the reason why it's been allowed to continue is because we don't want to come to grips with what is happening. And I think we find another word, even in another native language, or we call it something else, or we start adding adjectives and edges or, definitions to it, it takes it away from the uncomfortable position of where we are with genocide that's happening right now. It's not a maniacal leader that's killing a whole bunch of people in one particular moment, it's ongoing and people are dying. That's the thing. When the commission talked about it as like race-based genocide and how it was very sexually targeted, sex-based as well, then you understand that this isn't just Native people or blaming Native victims, that this is really targeted, and that Canada's policies throughout history have always been about eliminating and assimilating Indians. Now, they've changed their terminology over time, but the terminology still means the same thing. So you're talking about assimilation, forced, coerced, violent assimilation and loss of culture and life, that's still genocide. Or whether you call it integration, that's no better when it's forced, coerced, and violent, or whether you call it societal inclusion by force and violence and death, that's still genocide. And I think the worst thing we could do is give everybody else comfort by not using the term genocide, because what the National Inquiry did was brave. This wasn't a national inquiry into whether or not genocide was committed. It was, we're looking at murdered and missing Indigenous women and girls. What's going on here? And they came to that conclusion. So it wasn't a predetermination, it wasn't a political decision, it was very organic. And I think that makes it even more significant that it's based on this fact and law, and it wasn't like a predetermination or a political motivation. And I think it's all the more powerful. So I think for sure we should use the word genocide and treat it in both factors, like to go to what you were both talking about. There's the criminal aspect to it, but the human rights aspect to it. So the way I approached it was through all of the international human rights mechanisms. There's also the criminal dimension, but I think they both lead to the same place. And I think we shouldn't limit ourselves to the criminal. We should keep it open to both.
I think when we look at the Genocide Convention as it is, and then we apply the facts of this particular context to that definition, which is what the inquiry tried to do, we can see, and a case was made in the supplementary report, that the elements as they stand are met in certain ways, as you've described, Pam, and as is extensively described in both the main report and the supplementary report on genocide. But I think we have to admit that there's a lot beyond what is in that definition that is happening today in Indigenous communities that is not addressed through this terminology and through this legal definition. And so if we bring it back to what is beyond the scope of what we see in the genocide definition today, I think there's still many people who will be excluded from the scope of that word. So if we maybe go back to the legal application of the facts to the law, how should we be progressing the laws on genocide so that we can see this type of context being addressed within that framework?
Well, the thing is, genocide is probably fair labeling, and again, we mentioned genocide denial, which I think is something that's always at risk, but I mean, obviously, genocide is probably the definition that is the least understood in international law. It is a very convoluted definition. There's a lot of differing opinions about what it means and what it has become, and we have come to understand certain terms of it with evolving jurisprudence and everything, but it is not an easy definition to understand. And interpreting international law is part of judges' job, of academics' job, of practitioners' job. I mean, we just have to talk about what is customary international law. Is that customary? That's the whole essence of international law, to interpret it. So what I'm saying is that we can have reasonable discussion as to whether what we're seeing of the past and of the present fits within the definition without being taxed of being genocide denial. We have to be careful, because I think reasonable people can disagree, and that is okay. What I hope this conclusion of the National Inquiry triggers in Canada and elsewhere, in the Americas, because Canadian Indigenous women have started for a long time talking to their Guatemalan counterparts, and there's a lot of similarities. My point is, if we have that debate, a reasonable debate, well, it is a positive thing. So we can disagree, that's fine. I'll get to your more specifically to your question. Is the Genocide Convention good or bad? Be my guest, answer it to me. I don't know. I don't think it's the best definition that was ever drafted. That's what we have. And I think experts have said for a long time, there's no option of reopening the definition and trying to, at least at current, and maybe others have new perspectives. So we play with that, but what we've seen, and I think Catherine has mentioned it, is an interpretation of the convention that has become basically fixed in time. We interpreted it, and pretty much based on the travaux préparatoires, which, as you said, is a very not orthodox way to interpret a treaty, and we could go into this as to how the travaux préparatoires can be. So if you interpret the treaty as it is now, usually what people do basically, and notice it happens a lot in how law evolves, we copy and paste what others have said before. So people have said, oh no, that's, destruction in the definition only includes physical and biological destruction because. And then all of a sudden you see that same passage being replicated. And it's very difficult to sort of undo what seems to have become the majority interpretation without, but it's not necessarily right. And I think the courage for all of us looking at international in general is to not always just sort of take it for granted, particularly students. It's not because Bill Shabas said this, he's my thesis director and I love him, but it's not because he said it, that's the law, right? So this is where we're called to do, look at a definition and interpret it with all the tools we have. So should we reject the narrow definition? There's no narrow definition. It is a little narrow, but if you have another way of interpreting, and if you look at TWAIL scholars, do you know what TWAIL is? Third World Approaches to International Law, critical legal theorists, and a lot of other ways of interpreting international law, you'll come to a very different conclusion as to what is included in the definition, in the text. I'm not talking about adding a paragraph. I'm talking about interpreting it. And we have been very, very, very timid in doing this. We just repeat what has been said in different contexts. So what the National Inquiry has done is not even, I think, expanding the definition. Is to look at it through a different lens in the context that we had. And it's not the only interpretation that exists that is different from the classical interpretation. So if you allow me, I think I have time, just on one major issue, okay? The TRC, the Truth and Reconciliation Commission, came up with the word, cultural genocide. And fine, their mandate was to look at residential schools. And maybe they didn't have the sort of facts and evidence to come with another conclusion, and that's fine. This commission is different. Pam mentioned it. There's all this sort of point in time where everything that was brought to them was way broader than, for instance, what was before the TRC, past reports. And at a point in time as well where international has developed, etc. Okay? So if you take that point in time, look at the facts, then the point is, you look at the definition, say, what's the main problem with the definition? That people have always said, that's why genocide doesn't apply to indigenous, violations against indigenous people, human rights. It's that definition or interpretation of the word destruction, right? So intent to destroy, the specific intent to destroy. Yes, there were transfer of children. Yes, there were murders. Yes, there were sexual violence. You know, the prohibited acts? Yeah, let's say reasonable people are like, oh, yeah. But, the essential ingredient of the genocide is missing. Specific intent, dolus specialis. And then, okay, so what is it? So if you look at it and you look at the evolvement of interpretations around the world, it is not true, in my opinion, in the National Inquiry's opinion, and in other courts' opinion and other people, that the intent to destroy is limited to biological and physical destruction. And fine, you can disagree, and tribunals have said this, and there's a lot of conflicting jurisprudence, but I think if you look at the evolution of the law and of the way to interpret the convention, its context, blah, 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 you can come with a reasonable and plausible interpretation that intent to destroy is intent to destroy physically, biologically, and the group understood as a social unit, as its very existence. It's the real physical sort of destruction of the group, but not in a murder way. And if you look at the acts that are included in the definition, it makes sense, okay? Because it never really made sense that you could biologically destroy a group by raping. You know what I mean? This is how it doesn't work. It doesn't. So anyway, that's an interpretation. Please, and have fun with it, play with it, but it's not trying to use a term and use it in a wrong way and to, sort of expand the definition so as to, have the word genocide lose its meaning. No, I don't think it is. I think it's another way of looking at it. And I think that's what the National Inquiry said. It happened in the European Code for Human Rights did that, but the German courts interpret the definition differently. So just look at it with this understanding. We can all disagree, or we can all, it doesn't matter, but it's not using a term that's too restrictive and trying to play with it to just make it sound like genocide. No, I don't think that's it. I think it's another way of interpreting genocide, which is a plausible, and it's a plausible way of interpreting it, and not just a way outside the door to use the term to make it sound, you know, to like make a big splash out of it. And that's something that came out in the media, and I think that was wrong. And that was exactly that discomfort of people using the word. That's not what it is. Yeah. So.
Thank you, Fanny. I'd like to just slightly switch gears just a little bit, or shift from the legal definition to the objective of why we even have this international justice project to begin with. The legal international justice project was developed to end the practice of genocide and other atrocity crimes, and it seems that the lack of diversity, not just in the drafting process, but in its interpretation throughout the years, is hindering this goal. So, Pam, I would like to ask you, how can we reconcile the very narrow scope of international criminal law with the reality that there is state impunity for ongoing structural policies of colonial violence? Are we taking for granted that international criminal justice is the best forum for Indigenous communities and allies to try to end this impunity?
Well, after everything that Fanny just said, obviously it's very complex. We're in an area that's very uncomfortable for people, and also relatively new to be talking about Canada or the US or Australia or New Zealand engaging in genocide. I mean, as soon as the report came out, I got tons of calls from people in the US saying, come here and tell us, you know, what our options are. But I wouldn't want us to get so focused on criminal law principles without the corresponding and associated and affiliated human rights context. Because, I mean, the submissions we were making was that this all come about by a failure to protect the human rights laws that exist there for people, but also a breaching of those laws. So it's both of them, and that's how genocide, it's the nature of genocide. It's the most horrific breach of basic human rights. Whether they're Indigenous peoples or non-Indigenous peoples, it's genocide at its heart is about this breach of what's considered human rights norms. And so I don't think that we should just see it strictly in the criminal sense, but even if that's the path or one particular strategy in any particular context, we have to remember that the law is organic and it's fluid and it adapts over time, and none of it can be frozen in law, like you were saying. Think about Canada's Constitution. It is considered a living tree. It is organic. It is interpreted all the time, and the words don't even have to actually be in the Constitution. Section 15 of the Charter guarantees equality between men and women under the law. Everyone knows that. And when certain cases, the Corbière case was brought, the Supreme Court had to think, okay, when you discriminate against Native people who live off reserve and don't allow them to participate in the governance of their community, what is that? Is that racial discrimination? Is it religious? Like, the words weren't there, but we're not limited by the words. We're limited by the actual intention of what those laws are meant to do. The intention to prevent discrimination under the law between men and women or people of different racial backgrounds. And so they read in an analogous ground of aboriginality residence. You still don't see that in the Charter, but it is the law. And so genocide is no different. It's essentially this, international charter on how we prevent the worst human rights abuses possible. And we did it, it started out based on a certain context of what we knew or what people were willing to put on the table, but it's also very insidious. There's words that are missing for particular intentive motives to make sure Indigenous peoples in Canada and the US and Australia and New Zealand couldn't bring forward claims of genocide. And so we have to take that into account as well. All of the discussions that were happening around the time. Think about when the Supreme Court of Canada interprets treaties. You don't just read the word of the treaties. You read all of the negotiations around the treaties, all of the treaty minutes. Well, I think we would be well served in our submissions to say, well, you know what, when you're interpreting the term of genocide, you cannot let someone do indirectly what they cannot do directly, and that is benefit from the purposeful intention of making sure that our criminal and genocidal acts don't get included. That it was just the fact that they purposely excluded it is evidence, some sort of evidence that they were well aware that this was wrong. And I think the other side of the coin is also that Indigenous people weren't there and women weren't there. And when I say weren't there, it's not just in the drafting of the definition, but they're not the ones at the international courts making these decisions. They're not the international lawyers helping to inform any of this. So when I think about, you know, addressing the lack of diversity in, you know, both the, the definition, it's also where we are and where we aren't. You don't see us sitting on these commissions or human rights treaty bodies or international criminal courts. And that's a problem because they're also lacking that, that background and that context, which wasn't the focus at the time. It was very, very reactionary, but it doesn't mean, just like a constitution, that it can't expand, it can't be, not expand, but be informed to a different context, like any law. You know, you think of any basic criminal law, is this murder? Well, in this context, with new changing fact scenarios, we constantly have to do that. So I don't think we should be very rigidly focused there. Otherwise, we then, through a bitter irony, allow to continue what we intended to stop to begin with. And if the objective is to end genocide, then we have to think about genocide more broadly.
Thank you. Do you want to add anything? Are we going to go to questions? Oh, I'm going to go to the victims. So I'm going to wrap up now just and switch gears before we open it up to questions. Thank you, Pam, so much for that. I wanted to add this extra focus in here because I think it sometimes gets lost. And as an international criminal lawyer who primarily works directly with victims of atrocity crimes, I want to end our discussion on the people that the justice is purportedly for. Throughout my personal work, it's clear that there is no homogeneity in the experiences, desires, and objectives of victims and survivors of atrocity crimes. All want justice, but what that justice looks like will vary. Many want to forget, and many cannot forget because the atrocities or their consequences are ongoing. Many want their immediate needs addressed, and that's often material needs. And in my experience, most survivors want to be heard and they want to be believed. Now, I don't think that international criminal law was ever built to achieve all of that. That was not the purpose of international criminal law. And the focus of international criminal law, as we've said before, is on the perpetrator and not often on the victim. But and I think that's why a singular focus on international criminal justice is insufficient, and that's why the National Inquiry made over 200 calls for justice that can be acted upon and implemented here in Canada that are much more holistic. They're looking at social, economic, medical, security, and other practical remedies. But accountability is also an important part of justice. And with atrocity crimes, survivors often have to look beyond their borders for tools and for forums to hold perpetrators accountable, be they individuals or states. And that's the reason we have a Genocide Convention and a Rome Statute. It's because we've recognized that the international community has to hold its members accountable for the most egregious conduct. The Genocide Convention's preamble recognizes that, quote, at all periods of history, genocide has inflicted great losses on humanity, on people, and that the convention was drafted to, quote, liberate mankind from such an odious scourge. Throughout the years, international criminal justice has evolved to a point where we do recognize the importance of victims, of their rights of participation and redress. We recognize that victims shouldn't be instrumentalized and they shouldn't be ignored in the pursuit of accountability, even if practice doesn't always reflect that principle. And we've certainly recognized that there is no international crime nor justice for that crime without the victims. The Rome Statute, just as an example, is very progressive in its inclusion of victims. Procedurally, the Rome Statute allows victim representation before the court, victim participation, access to the victim's trust fund, though not with its own complexities and controversies. So When we limit the scope of international crimes as a result of a lack of diverse perspectives and lived experiences, not just in the drafting process, but as Fanny mentioned, in the interpretation, in the constant and continuous interpretation of the crime, it's not just an issue of semantics or language. With all due respect to Payam, who spoke yesterday, I don't think that it's just a matter of labeling, is this genocide the way we see it or not? We're also excluding very particular types of victims and depriving them from access to the legal instruments that we have that currently exist. Victims who are part of the most marginalized, disenfranchised, and underrepresented cultural, social, or economic groups. And it's not just a momentary exclusion. The ramifications are long-lasting. We see today a denial of access to justice for Indigenous victims because of decisions that were made not just in 1946 and 1948 or 1993 or 1998 with the drafting of other statutes, but because of ongoing interpretations. And so when do we stop and change course? In the last 2 decades, we saw incredible progress in understanding sexual and gendered violence as an international crime because the victims and their advocates pushed the boundaries of what was to be recognized within existing frameworks that we had. And I think that this is precisely what the National Inquiry has attempted to do with its legal analysis on colonial genocide. So I'm going to wrap our session up there. I want to thank everybody very much for their contributions today. We're close to running out of time. We have about 10 minutes, 15 minutes for questions. So I encourage you to come to the microphone if you have a question. But I would also like to ask everyone to respect one guideline. We're privileged to have some incredible women, Indigenous women here with deep expertise on this topic. So please do make the most of your time by asking an actual question, especially one that you think would benefit everybody in this room. And kindly reserve your comments for the social breaks where we would be happy to hear what you think and what you have to say. Thank you.
On your first question, the primary problem, given that the state is the perpetrator of genocide, generally the solutions I wouldn't see as originating from the state or what I would call tinkering around the edges. So what's the most comfortable to federal, provincial governments is when, if forced, they have to make an amendment to their law, but it's just literally tinkering around the edges. They still maintain the structure, the control, all of the problems, but maybe add something like a, customary international law. That's not going to or customary adoptions, that's not going to address it. A full-blown recognition of First Nation sovereignty and jurisdiction over our own children and our own families and child welfare, that would go a long way towards addressing all of the problems in foster care with a particular gendered lens where Indigenous women are actually leading the changes that need to happen. I think far better than little tinkering around the edges. And on the other question about this helping other Indigenous women. In fact, we got a lot of help from Indigenous women all around the world. Some of the women from Mexico were our best advisors when we were at the United Nations treaty bodies or the Inter-American Commission about the struggles they've had about disappeared Indigenous women and how they've advocated and things that they've tried. And we're trying to collaborate more and more and more with Indigenous peoples around the world, both at the UN treaty bodies and especially the Inter-American Commission, who has taken a very keen interest in this finding of genocide, and we just met with them a few weeks ago, and they literally want to help Canada oversee the ending of genocide in Canada, which is just, these are the kinds of things that we want, these are the kinds of results and impacts that we want. And if Canada can't do it, okay, but to have help, external help and independent help, I think that's something that would just be wonderful for us.
We had a discussion, I just want to say, because your question raises also the sort of critique that came after the genocide finding. Oh, it overshadowed everything else and it didn't give. Well, just one thing. you know, if this is the fair labeling, Canada goes around the world telling, you know, other societies to, you know, be able to name, to process, to transitional justice issues. And in this case, it was like, oh, well, don't bother about the word, you know, because we'll focus about your little recommendations. I just want to say one thing. Genocide, as one of the other human rights violations, let's put it this way, comes with consequences, legal consequences. And I haven't heard much about this in Canada following this. And this is one tool, the genocide conclusion. There are other human rights violations. Comes with the implementation of the 231 calls for justice, and the ones before this at the TRC, and the ones before this at the Vien Commission that just came out in Quebec. They are, if you put it this way, legal obligations flowing from the breach of international obligations. So if you look at it this way, it's not really overshadowing. It's actually forcing the implementation in a reasonable way in consultation, blah, blah. So we have to see it this way, rather than saying, oh, the debate is like, no, the debate is not irrelevant. It is actually central to what follows.
When we talk about intention vis-a-vis the state versus an individual, there are different ways of assessing that, and that's something that we brought up in the report. And so I want to pass it to Fanny, because this was kind of, I think the intention was maybe the crux of a lot of the critique and the issues with actually calling this genocide, because it wasn't just about the acts that are happening, as we've mentioned, but it's also, does the government of Canada have an intention to destroy, and how do we assess intent from a non-human person? It's a fabrication. It's a legal fabrication. So I just want to make that distinction clear before I pass it on to either Fanny or another panelist to answer your.
Well, very briefly, I think you mentioned it. It's a good question, actually. And it's interesting how exactly as I invited all of us to look at the Genocide Convention from a human rights perspective and state responsibility, how do you establish the legal elements of the act of genocide in case of a state with words that are sort of, so specific intent. States, you know, states don't have intent. Individuals have intent. You know, you intend to do something. States have policy. So the specific intent to destroy is evidence, is determined in a context and with a manifest pattern of conduct in policies which aim at destroying. That's one of the interpretation. That's one way of trying to understand this. So that's why, again, the undoing genocide or stopping the violations mean stopping some of the policies that Pam mentioned that still contribute to this policy of destruction. Do you understand it? So it's really an invitation. So yeah, is an external court not? Well, yeah, it will help for the state to see itself as perpetrating some policies that have that intent. So it's not me having the intent. Nobody here. This is what people said. No, we don't want destruction. You know, there's something really emotional about, no, the Canada doesn't want to destroy it. And just people, look, it's not about that. It's not that. It's really seeing intent to destroy as policies. And it's a different mindset from us to look at it than if you think of someone and individuals having an intent to destroy. It's not about our aggregate intents to destroy indigenous people. It's not about that. It's about Canada's policies that aim at destroying, which is different. Hope it answers your question.
And I'd like to just add that it's not just policies that inflict, but it's also policies that omit. It's policies that deprive equal funding, or that deprive. So I think that that's also part of this interpretive work, which is let's look at this wholly and try to understand what those policies are and how we can then apply that as a form of intent.
No, I was about to add, like, similarly that you just did. So the absence of action, or the absence of a specific policy, or the letting go that there is no access to water, there is no access to medical care, all this absence of action elucidates the specific intent of a state in that context. So it's both the action but the omission as well in the case of state intent. That's really important to highlight, I think.
And I would just add, because I'm a little on the crankier side of things, that there is both state intention through policy and state intention that can be evidenced through bureaucrats. So think about every year when federal bureaucrats look at funding for kids in foster care, First Nation kids in foster care, and they do intensive analysis, and they realize that, well, if we continue to underfund preventative services again this year, we can calculate how many kids are going to go into foster care. And of course, you know, by going into foster care, you're less likely to get an education, murdered, and missing, human trafficking. So they're making decisions knowing what the consequences are. So to me, that's an intention. And that goes, it's so deeply embedded, having, you know, worked at Justice Canada and Indian Affairs, it's so deeply embedded that many of those in those senior positions don't even realize what it is that they do every year, that they're making life and death decisions even when it's brought before them. And if you look at state intention, it was always to quote unquote get rid of the Indian problem, to quote unquote the final solution. And that's not me, that's coming from, you know, prime ministers and directors of Indian Affairs. And despite Justice Canada lawyers saying, hey, government officials, what you're doing is manslaughter. Okay, well, our goal is the final solution, so we're okay with that. That is intention by individuals, because the state's not just, I mean, while it is a legal entity, it's individuals who are running this legal entity, and you can't really separate those two. Or the intention to destroy a group. That intention still exists today. The Indian Act has a legislative extinction date for every First Nation in this country, a date in which there will be no more legally recognized Indians born according to the federal government, and then no more reserves, and it all reverts back to the Crown. That's an intention to wipe out a group that's embedded in our law today, despite all of the human rights. So the intention is very much alive in individuals and in the mythical state.
Thank you. Our last question.
Where are you? Okay, hi. About women, I'll let you answer, Kathleen, but I think it's by asking the question, okay? This is exactly it. Like, a gendered understanding of genocide means moving away from the traditional paradigm of massacres, you know, and so, yeah, so asking the question is exactly what I think this kind of work is doing, and others are doing this excellent work of seeing genocide through to this. So maybe you can answer more about this. Payam, I don't think we agree on whether you need an individual sort of commission of crime for the state to be responsible. I think state can be responsible for the act of genocide, which is a direct violation of international law, so attributing responsibility, why not? But then it's different in my opinion, and we can have a great lunch discussion, not. But what I mean is that I think you could say, okay, well, what are the principles of individual liability? So can we see someone here committing genocide? And within this realm, with this legal structure of individual liability, is someone doing this? It's different, I think, than what we think is how a state commits it, different than individual. So I mean, we can talk about this, but I don't think they're necessarily intertwined at all times. I think they're two different, they can be two different little legal ways of attributing liability. And civil litigation, well, interestingly, you know, the Prime Minister recognized or accepted after the genocide conclusion. It's interesting, right? You may say it's a political act, I don't mind, but if it is the case, then there's no need to further determine whether there's a genocide. Mm-hmm. If it is the case, of course it's, you know, well, there is, and so what are the consequences, right? But if it doesn't lead to reparations, and those, so to actually implementation of the recommendations, then I suspect people will start saying, well, then we'll go have a court tell us it is, you know, and genocide. So we'll see. I think it's great possibility for Canada to enter into this real discussion, reconciliation, without having to go to court again. That's part of what decolonizing means. It's another discussion for another day. But I think it's exactly where it points at. Why fight again if it was recognized? It's a good question.
I'll just jump in on that before we turn back to the other question, is just that I do believe that before the International Court of Justice, in the case against Serbia, there was a determination that the Genocide Convention doesn't just place an obligation on states to prevent or punish, but by virtue of that obligation, they also should not be able to commit. And when they looked at, state organs and whether they could attribute the actions of a kind of separatist, kind of affiliated group to Serbia, they determined that they couldn't based on those facts, but the exercise was there because you could attribute responsibility to the state for the commission of those crimes. At least that's how we interpreted in this analysis. So I just wanted to flag that. But I also want to talk about civil litigation because what we've seen in Canada to date, perhaps not civil litigation of genocide, but we have seen various cases that have been litigating some of the various components of what we've classified as genocidal conduct. So the underfunding of children in on-reserve welfare, that's been litigated for the last, 12 years, 8 years, and the government just this month, decided to appeal a decision that was made in favor of these Indigenous children. So it is possible to go through the civil litigation route, but then we also have to acknowledge the limitations of this piecemeal of this one specific policy and how we go about that. So I just want to flag that it is being done, but in various different ways.
So I'll just add on quickly concerning your question on gender violence and genocide. I'd just like to add that there's optimism to have. It's a relatively new body of research. First research on that started in the 1990s with the works of Katrin McKinnon, if you're interested, and eventually the ICTR case law, and then after that there was a huge rise in scholar studies on gendered approach to genocide, and it's always increasing. So as Fanny said, it's by asking the question, it's by writing on it, and also by emphasizing how that relates to maybe a broader kind of destruction than the, let's say, traditional approach. And there's also a whole body of jurisprudence on that with the German court and the European Court of Human Rights, the Georgic case. Also, if you're interested, it's really important with that respect. So yeah, there is optimism to have, and we must keep the discussion going.
Thank you. I'm in trouble. I've kept you guys throughout the break, and I'm so sorry, but I'm glad to see such an engaged and interested audience. So I want to thank you very much for spending your time here today with us, and I'd like to really thank everybody on the panel for your